Okay, so this is Decent We the People News. All right. Again, I'm not an attorney. I'm not giving legal advice. However, this is a learning video. Okay. Think outside the box. Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. And this is very important on this one as well, because my past videos we talk about the 4 USC 101. Right. That every one of the officers has got to take this oath, and they do not do it. But this is the funny thing is, right? And I believe a long time ago I talked about this. However, I think I said 1995, 1997, but it was 91, when Congress changed the oath. But so this oath they're talking about was one of the oaths they're supposed to take, okay? But it's one of them out of the oaths, they got several oaths that they can take, okay? But the main one was the 4 USC 101. Without that oath, then all other oaths are null and void, right? We just don't know these things, so we don't challenge it, okay? This one is particularly talking about how it's written on this particular type of oath, which is Article 28, okay? When they change the words, it makes everything have different meanings, right? Words matter in law. And you guys heard me over and over, right? Trickery of words. So when Congress changed the oath of office for the federal judges, by the way, it diluted down to your local judge today. If you read the oath, it basically says the same thing. So even though he is talking about federal courts, it trickled all the way down to all the other oaths. So basically, well, he'll explain it. I'll shut up and proceed forward.
Judicial power of the United States, to get a little background on what was behind this case. All right? The judicial power reflects that certain constitution ordained and established September 17th, 1787, and implemented March 4th, 1789. Now, we have to be specific, right? Because we know there are several constitutions that are referred to and designed to confuse and obfuscate law and reality. But the judicial power comes from Article 3, Section 1 of that Constitution. All right, and then if we look at Article 6 and Clause 3, this provides for the prevention of arbitrary exercise or abuse of the judicial power of the United States by way of a requirement that all justices and judges of the United States be bound by oath or affirmation to support the Constitution, right? Now that's not news, but it's important for us to understand the nexus by which the Constitution can require its support, enforcement, and execution. All right? And within the Constitution, it requires this oath or affirmation to support the Constitution. All right, and here's what it says. Quote, the senators and representatives before mentioned and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. Now, that's pretty plain language, all right? You don't need a law degree to understand that. Simple. Anybody put into office to execute the laws of the United States must be bound by oath or affirmation. Simple, fair enough. So let's look at the justices and judges' oath of office. In Section 8, I quote, and be it further enacted that the justices of the Supreme Court and the district judges, before they proceed to execute the duties of their respective offices, shall take the following oath or affirmation to wit. So here's the oath, right? I John Smith, do solemnly swear or affirm that I will administer justice without respect to persons and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me as, for example, district judge, or whatever the title might be, according to the best of my abilities and understanding, agreeably to the Constitution and laws of the United States. So help me God. So what this is saying is that every officer is going to work to the best of their abilities, the best of their training, knowledge, and understanding, that their actions will be in agreement with and conforming to the principles and mandates of the Constitution and the laws of the United States. Of course, the laws of the United States are subject to the Constitution, which is the supreme law. So, that being the case, let's see what happened with that. Congress materially alters the oath. Okay, so what does Congress do? Congress, on December 1st, 1990, in Public Law 101-650 at Section 404, which you can find at 104 Stat 5124, that's Statutes at Large, for those of you who are not legal researchers. That's volume 104 of the Statutes at Large, page 5124. Okay, effective 90 days later, they alter materially, by way of amendment, the oath, which we just read, which is found at 28 U.S. Code Section 453, so as to relieve all the justices and judges of the United States of any duty of fidelity to the Constitution. Okay? Now, any of you who have been in court or who have been looking at these issues over the years, you've heard and seen many times where someone raises the issue of the Constitution and the judge says, if you mention that one more time, I'll have you thrown in jail for contempt. And you're kind of scratching your head like, well, how can that be? All right, well, now you're finding out how it can be. The judges do not have duty or fidelity to the Constitution anymore. All right? And so we can go and look at that public law, Section 404. The section is titled Amendment to Oath of Justices and Judges. In Section 453 of Title 28, the United States Code is amended by striking out, according to the best of my abilities and understanding, agreeably to, striking out those words and inserting under in its place. Okay? So now the oath reads, I do solemnly swear or affirm that I will administer justice without respect to persons and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all duties incumbent upon me as, example, district judge, under the Constitution and the laws of the United States, so help me God. Okay, now, the average individual looking at that, reading that, would say, wow, well, that sounds pretty much the same, doesn't it? I mean, what's the big shakes there? Okay, let's look at that oath again, visually, for those of you who...
And let's pause there for a second. Again, I'm not an attorney, so it's just my opinion, okay? But, now, are these judges really actually even with this oath? Right? Equal justice from the rich, from the poor? Are they doing it equally? You got corporations out there running amok, and you can't get justice. Just saying. So even with their nowadays oath of office, they still violate it.
Or online, we can see here where they took out those words, according to the best of my abilities and understanding, agreeably to the Constitution, and they just says, the duties incumbent upon me as district judge under the Constitution. So they're referring directly to the duties incumbent upon that official under the Constitution. All right? not in agreement with the Constitution to the best of my abilities, but those duties incumbent upon me under the Constitution. Now, here's why that is so important. We could say, but the only duties incumbent upon justices and judges of the United States to discharge or perform, those duties are only provided in the statutes created by Congress.
There we go. Kind of like the Bundys, okay? During that ranch war, basically. Okay? The judge on public TV, by the way, said there was no room for the Constitution in my courts. Why? Because that judge did not take the correct oath of office and went by only statutes. That way, it violated the due process of constitutional rights with the Bundys. Because under that oath, it wasn't obligated to go by the Constitution. It was obligated to go by the statutes. Okay? Which makes it what? Very important them to still have the 4 USC 101, right? Because it's a short version, right? I, John Doe, swear and affirm to uphold the Constitution. That's it. Not laws, not anything on that, but to uphold the Constitution. It doesn't say help me, so help me God or anything. It sticks to the one particular deal. Uphold the Constitution. But none of them takes that 4 USC 101 because that bounds them. And it takes away from that authority of only going by statutes so they can violate your rights. What we got to do is put in our paperwork, where's the oath of office, the 4 USC 101. That goes for your cops, sheriffs, your mayor, your local township. Anybody that has to take any oath must take that 4 USC 101. And it's a must. They have to do it. So they even breaking the law, by the way, by not taking it.
28, Judiciary, the laws of the United States. The Constitution doesn't provide any duties. It doesn't get down to the nitty-gritty. The Constitution stands on principles. It isn't a micromanagement document. So there are no duties for judicial officials outlined in the Constitution. Okay, so let's continue. The 1990 oath severs the connection between the federal judiciary and the Constitution. Meaning, as of March 1st, 1991, officers of the federal judiciary have no obligation to discharge or perform the duties of their respective offices, like it used to say, agreeably to the Constitution. Those words were written out, weren't they? And the former judicial branch officers are now legislative branch officers under the exclusive control of Congress. Let that sink in a little bit. What does that mean? That means that the independent judiciary is no longer independent. Congress merged the judicial branch of government into and under its own auspices. Is that sinking in? That's huge. Okay, now here's a Latin term. I'll give a prize to the first person who can pronounce it correctly. Plus peccat autor quam actor, I think. Okay, which basically says the instigator of a crime is worse than he who perpetrates it. That comes out of Bouvier's Law Dictionary. And the instigators of the takeover of the federal courts of a limited jurisdiction by municipal judges masquerading as Article 3 judges from the Constitution, which they are not, and usurping exercise of general jurisdiction throughout the Union, those instigators are the members of Congress, who are the real culprits. Now, certainly the judges and judicial officials are co-conspirators. They're supporting actors. You know, they signed up to do a job and they took the oath that they were given. But they know full well what it meant, and they know full well what they're doing. So they're not acting without knowledge. So because there's no provision of the Constitution that requires a justice or a judge of the United States to discharge or perform any duties, there are no duties under the Constitution incumbent upon any such justice or judge to discharge or perform. So this is why in the Lufkin action, the U.S. attorney went silent for the duration of the case, 5.5 months. When the petitioner demanded the provision of the Constitution that gives the court, i.e. the judge, the capacity to take jurisdiction and enter judgment in Tyler County, Texas. So the petitioner was challenging jurisdiction. He was saying, show me your constitutional authority to take jurisdiction in this case. You're a federal court. You have limited jurisdiction. I'm in Texas. What are you doing on my territory? This is not federally owned land. It's not a dock. It's not an arsenal. It's not a territory. You have no constitutional authority. And neither the court nor the United States attorney was bound by oath or affirmation to support the Constitution. So you see now why they were silent for 5.5 months and failed to respond. So to prevent the fissure or the splintering of the federal judicial system, where we might have one set of justices and judges to discharge and perform their respective duties agreeably to the Constitution, like the old oath required, and then another group of judges and justices not doing that. What happened was between December 1st, 1990 and February 28th, 1991, all sitting and newly commissioned justices and judges of the United States take the new oath of office. Okay, so they get all the old guys to take the new oath, and then from that point in, everybody taking office thereafter would also then take the new oath. So everybody was on the same game plan. And no justice, no judge of the United States is bound by oath or affirmation to support the Constitution. Only the laws of the United States. Pretty sweet, huh? In the old days, they used to have wars to take over governments. In this case, they use lies, deception, and laws to take over the government. So let's just review the limited jurisdiction of the federal courts. I know most of you probably have had some exposure to this and understand this, but let's just review it. Let's kind of bone up on it a little bit. In the Supreme Court case of Rasool versus Bush, the Supreme Court said, quote, "As we have repeatedly said, federal courts are courts of limited jurisdiction. They possess only that power authorized by the Constitution and statute." All right? The Constitution is very clear on what power it extends to both the judiciary and the Congress, and it's very limited. All right, so this is why the petitioner in this case was so persistent. The justices and judges ensconced in the federal courts of limited jurisdiction are usurping exercise of territorial jurisdiction, which is an aspect of general jurisdiction, and they're entering judgment against the people. They're directing the disposition of their assets. They're committing theft under color of authority. That's Title 18, Section 241, denial of rights under color of law, federal crime. And in this case, they were doing all that to the petitioner's property in Montgomery and Tyler County, Texas, which is a geographic area in which Texas possesses the exclusive jurisdiction and sovereignty over the property located there. All right? So again, the Supreme Court tells us in Pennoyer versus Neff, quote, the several states of the Union are not, it is true, in every respect independent. Many of the right and powers which originally belonged to them being now vested in the government created by the Constitution, but except as restrained and limited by that instrument, the Constitution they're referring to, they, the states, possess and exercise the authority of independent states. And the principles of public law to which we have referred are applicable to them. One of these principles is that every state possesses exclusive jurisdiction and sovereignty over persons and property within its territory.
Now, there we go again. Right? I've talked about persons. Trickery words matter. Alright, so we're going to go ahead and stop it there, y'all. This video's been long enough. But the gist of more of anything else is the oath. That has tricked us and misled us into believing they actually have a real oath of office. Due to them not taking the article, the 4 U.S.C. 101, lets them still get by violating your rights because they are ignoring the main one, which strictly goes uphold the Constitution. No more, no less. That bounds them to it. And since they don't take it, and when we go up there and when we challenge them, are you going to uphold the oath? I accept your oath and all that. Well, what oath you are accepting them? Because the one oath that really has power is the ones that they're not taking. Just saying. Do so with the People News. Till next time. Bye, y'all.